We now turn to the second case on this morning's docket. That is case number 108929 in the matter of Scott C. Stockwell, respondent.
May it please the Court, I'm Alexander M. Walzak, Deputy Disciplinary Administrator. A panel hearing was held on September the 18th, 2012, where the respondent stipulated that his conduct as charged in the formal complaint violated two ethical rules. 3.3, candor towards the tribunal. This was concerning a pleading to the court that contained material misrepresentations, as well as 3.5 for engaging in an improper ex parte communication where he met with the judge in an adversary proceeding ex parte without noticing opposing counsel. The respondent, in his amended answer, admitted to most of the factual allegations charged in the formal complaint. On review before this court, the respondent did not file any exceptions to the findings of facts or conclusions of law. At the panel hearing, and I believe before the court, the only issue before the court is what is the appropriate discipline for the respondent's conduct in the case. At the panel hearing, prior to the conclusion, the respondent submitted a proposed plan of probation. He was quizzed about the plan of probation during the hearing, and at the conclusion of the hearing, I recommended the appropriate discipline to be 3 months suspension from the practice of law, but approval of the respondent's plan of probation. His plan of probation provided...
Counsel, did you say 3 months?
I'm at 3 years. I'm sorry. His proposed plan of probation called for 2 years. During the proceedings, he amended it to 3 years, and I recommended at the conclusion that be suspended for 3 years, that suspension be stayed, the plan of probation be approved, but approved for 3 years. The respondent recommended the plan be approved, his plan be approved for 3 years. The applicable ABA standard is 6.12, which calls for a suspension. During the discussion as to appropriate discipline, I introduced 4 records of prior attorney discipline. One was a censure imposed by this court. The other 3 dealt with informal admonitions. And the obvious questions before the hearing panel and before the court, and that is, in light of the respondent's record for prior attorney discipline and the seriousness of the misconduct in the case, why probation? And the answer I gave to the panel hearing, in which I gave to the court, this court, is that I had known the respondent through some of the prior records of attorney discipline, as well as that periodically he would call seeking guidance. And looking at the misconduct on the case, while it is material misrepresentations to the court, as well as, I believe, significant misconduct in dealing with an adversary and not noticing the court and the opposing counsel of the other involvement, I didn't see it was intentional dishonesty, more of a combination of extremely poor judgment and not knowing what to do, how to go about it. And even though this attorney at the time had about 27 years attorney experience.
You think that wasn't long enough to know that you don't lie to the court?
Yes. I mean, that's obviously, Your Honor, it's pretty basic. You don't need to be an attorney to know that tell the truth or not to tell the truth.
And how do you fix that with probation? How do you fix that kind of dishonesty with probation?
Well, the dishonesty here is he filed pleadings representing that the deceased died intestate. He wrongly concluded that the will that he saw was invalid for a number of reasons, and therefore, because it was invalid, the decedent really died intestate. I'm not trying to defend it, but that was his logic. And rather than doing it the appropriate way of pointing out to the court that there was a will and that he may have grounds to challenge it and inform that to the court as well as notice opposing counsel, he just did it. Now, yes, but that I saw in his explanation and the way the facts of this case is that the hearing panel correctly concluded that the proposed plan of probation was not put into effect prior to the panel hearing. He has submitted it timely, but he did not start the balls of the terms of the conditions going until he planned after the hearing. So under Supreme Court Rule 211G, the plan of probation could not be approved by the hearing panel, as well as the hearing panel pointed out that the respondent's conduct did involve dishonesty, and probation generally does not correct dishonest conduct. Before this court today, I'm recommending that the panel hearings, findings, conclusions of law, and recommendation for discipline, that is, suspension for 1 year, be approved.
Any questions of counsel? Any further presentation?
None. Thank you, Your Honor.
Thank you, counsel.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. No doubt the conduct was egregious. No doubt that no one up there, anybody in this room other than Scott, would have done what occurred in this case. Nobody would have filed the pleading before Judge Ryland. No one would have, in a conference with the judge, not let the other side know that it's time to come to the courthouse, I need to do this. It was egregious. The panel was right. My colleague is right. Scott admits it. The question is, number one, can probation do something to solve his problems? And the bigger question is, why in God's name did he do this? That's the question. Nobody else would do it. Why would he do it? He doesn't get it. He didn't get it. We've got, and I've said this before, either in answer to Justice Biles' questions 2 or 3 months down the road or somebody else's. We have a group of lawyers in this state who don't get it. I don't care if they've had 27 years practicing or 40 years. They don't get it. They haven't had the training we've had. They haven't had the benefits we have. They haven't had the mentors we've had. They haven't had the people who would say to us, you can't do that. If I had done this in the public defender's office when I started out or in my law firm, I would have been eviscerated by either the chief public defender or the chief partner, the head partner, in the law firm that I attended. And all of you would have the same. I would have also had somebody to run this by. Can I do this? He doesn't have that benefit. He's operating on his own. He's by himself. I'm not excusing. I'm not making him a victim. All I'm saying is, was this a mean-spirited lie, or did he not know what to do and that got caught up in the moment? And I think that's what my colleague is suggesting. Well, I don't mean to speak for Mr. Walczak, and he certainly was defending it. But Mr. Walczak, that's why he wanted to give this individual a break. And Mr. Walczak is tough on all of these guys. He just chose not to do that for him, and I think he was right. And the reason I think he was right is because we have put in place now, since September, a plan of probation with an absolutely wonderful supervisor named John Becker. And when we were talking the week or two before about this, he said, I'll do it, but he's not going to file anything that I don't look at, because we're not going to have anything like this happen again. And see, if he had had a Mr. Becker in his corner before, or John Ambrosio, or an Al Walczak, or one of you in that firm, he would have come to you and say, can I do this? And you would ask if he had lost his mind.
So Mr. Becker is prepared to look at every pleading your client's preparing to file and have a one-on-one conversation with him and go through line by line. Is this true? Is this true? Is this true? Is this true? Am I understanding correctly? He's willing to do that.
Mr. Chief Justice, absolutely. And that's what he's told me.
And why would any lawyer in Kansas be required to ask that of another lawyer who's practicing law? Isn't there something basic that's flawed here?
Sure, there's something basic that's flawed here, Mr. Chief Justice. Scott is basically flawed. He should have known, and he needs that type of leash around his shoulders, around his throat. He needs that type of harness. Yes, he should know. Yes, he should definitely know. I don't fight with you about that at all. And Mr. Becker said, if I'm going to do this, he's not to file one pleading until I see it, until we have a meeting. We also don't want him doing litigation, he's the wrong person for litigation. But Mr. Becker is willing to do that and has been doing that. He's audited all his files. He's directed him which files he's got to get rid of. This case that gave rise to this is still ongoing. It's still tortuously going through the litigation process.
So at the end of the probation and the end of the supervision by Mr. Becker, the belief is that your client will now know on his own to review all pleadings and documents to make sure he's truthful?
Absolutely. If he doesn't get up to 2 or 3 or 4 years, then he should be thrown on the dung heap finally. Absolutely, I agree with you. He doesn't get it now. He's slowly starting to get it. It's a torturous process for Mr. Becker to go through this. This is a guy my client, who counts angels on the head of a pin all the time. He doesn't get the big picture. He read 100 cases before he filed this pleading. You don't need to file 100 cases before you read this pleading. You know that you go to the judge and you tell the judge, there's a purported will on the other side. I don't believe it is. And Judge Reiling, who was a wonderful magistrate, would have said, I'm just going to set this for hearing. I'm not going to sign these things. And that's what he said in his stipulation, by the way. He now gets it. He understands he can't do it. And Mr. Becker is going to have the cudgel to hit him in the head if he continues or tries to carry out this type of conduct. Was it dishonest? I always hate to use the word dishonest. Of course it was. Did he try to pull the wool over Judge Reiling's house? Of course he did. Mr. Walczak is willing to give him a chance. Mr. Becker is willing to work with him. Is he worthy of a chance? I read the report, and they're right, because the case law said, would this change the conduct? If there had been a probation officer, a probationer, supervisor, in effect at the time, this never would have been filed. If he had had the chance to run this by somebody, this never would have been filed, or there wouldn't be an ex parte communication. I said to my client a number of weeks ago, I hope you don't have any angst or anger at the woman on the other side who filed this complaint. And he said, no, she had an obligation to file it, which she did. Most lawyers would have gone over with a 2x4 and got his attention. Maybe he'd get that. With no further ado, my time is running down. I'm going to have my client address the court if that's your pleasure.
Very well.
May it please the court. I'm genuinely scared. Excuse me. I'm genuinely scared about standing before you, knowing that your decision in my case may take something from me that I truly love to do. It scares me to know that I stand very close to not being able to practice law for the foreseeable future. I recognize that I violated the Code of Professional Responsibility and that I was not immediately forthcoming in my admission of the same. Looking back, I do not know why I was unable to admit my mistake, why I committed the mistake in the first place. There was no excuse for not advising the judge of the purported will. I recognize that my perception that the will was invalid did not give me the right to fail to mention it. This issue was a matter about which the judge should have been advised, and I should have notified opposing counsel instead of approaching the court ex parte. During the pendency of this case, I have faced serious health issues due to a diagnosis of cancer. Perhaps my failure to immediately acknowledge my mistake was due to my focus on these health problems. However, I can assure you that I stand before you fully admitting the errors that I made, and I'm willing to take the actions needed to demonstrate to you that I can effectively and ethically practice law. I am very appreciative of Mr. Walczak's recommendations to the hearing panel, and I can tell you that a plan of probation is something that I am more than willing to accept and work on diligently. I have Jonathan Becker, who has been working with me on my plan of probation and who has been extremely valuable to me. Mr. Becker and I meet every week. I submit to him every pleading that I file in the court prior to submitting the same, and I rely upon him for support and for sound advice. It has been very helpful for me to have a mentor with whom I may discuss alternative courses of action and who I can trust to guide me in the right direction. I did not realize how important it is to have someone to discuss such matters with until I began meeting with Mr. Becker. I also have the support of my wife and children who have supported me throughout this case and my illness. I truly believe that I can be successful in probation. I have been practicing law for over 28 years, and I believe that I've helped many people during that time. While I've made mistakes, I believe that with continued guidance, I can continue to successfully practice on the probation plan as I have since September of last year. I ask the court to allow me to continue to practice under the probation plan.
Do we have any questions of either counsel? Thank you both.
Thank you, Your Honor.
Thank all counsel for your arguments this morning. The court will take this matter under advisement.